We are very fortunate today to have three very experienced real estate transaction attorneys. Many of them you know, hopefully in a good way. And I will briefly introduce them. I'm not going to go into their bios because that would take the full hour. But one thing we were just joking about is on how much they're going to charge for answers. Depending on the quality of answer you get will be based on how much you're willing to pay.
You'll get what you pay for.
Yes. Okay, to my immediate left is Joel Grayson, and here's the other thing. Eyes and legs. All right, Joel is a partner in Grayson LLP Real Estate Business and Litigation Practice. He's been in practice for over 47 years. Joel represents real estate brokerages, realtor associations, licensees, developers, contractors, builders, investors, lenders, buyers, and sellers. He provides services in all aspects of real estate and business law, including planning, transactions, licensing, media, everything, okay? You need them for real estate, you got them.
Does that have been a paid advertisement? Yeah.
Next to Joel, many of you may know Jack Graham. The only thing I'm going to say about Jack is he used to work at the real estate agency, so he is...
And you notice they wouldn't give me a microphone?
Yeah. This is payback for all those times we had to be on opposing sides.
So he has a wealth of, let's call it insider trading. It may have been a while since he's worked there, but he certainly knows how the system works, how to navigate it, and he may have helped some of you in defending yourself or your brokerage or one of your other licensees when the real estate agency comes calling. He's a great resource right here in Salem. To the left of Jack is Richard Mario. Well, I learned today Richard lives here in Salem. However, his practice is up in Lake Oswego. He is a shareholder and attorney at Buckley Law. His practice includes business and real estate litigation, land use planning, and development and administrative licensing issues. Richard has a wide range of knowledge of the particular challenges faced by buyers, sellers, and brokers in the real estate industry. He represents these clients before governmental agencies and land use disputes and real estate licensing. Richard enjoys teaching more than 60 classes a year to real estate agents, title insurance reps, and other esteemed professionals, which means not lawyers. He is admitted to both. He is admitted to both the Arizona and Oregon bars, state bars, not bars.
Well, them too.
Yeah.
He's also a certified ski instructor. Wow. And enjoys skiing, mountain bike riding, and camping with his family. So maybe we'll host a CE up at Mount Hood. We'll do a little chairlift, gondola, risk management course. So you can ski and get some CE. So today the format I'm going to throw out a couple questions. We'll let them answer, and then we all know what happens next. You guys will have a ton of questions, and I have a friend that, and I heard another transaction this, and let's just open it up. And you guys know the rules, and of course you're up here with 4 attorneys, so we won't let you travel down the antitrust road, but this is your chance. As I told him, it's sort of like Lucy and Snoopy, the doctor is in. So you have a free hour and a half with attorneys, 3 very well-respected attorneys in your industry. So take advantage. I'm the free help. So when he says you get what you pay for, they ain't kidding. All right, so here's the first question. What is the number one issue you consistently see in your practice with respect to consumer complaints against brokers? Whichever one of you wants to start off. Joel? Jack?
Sure. I'm not sure that I would say consumer complaints yet, excuse me, but brokers getting themselves involved in Senate Bill 608 notices, not knowing how to navigate the issues with tenants that are in properties, and kind of stepping perhaps across the line beyond what their expertise is.
I'll try a couple of real quick ones. You want me to buy the mic? Can anybody in the back hear me?
They can now.
All right.
You broke it.
That's why they wouldn't give me one. Well, one thing is that there are always a tremendous number of new issues coming up. Needless to say, 608 is one of those. And all that I heard from February for the next about 5 months was this is just going to be a catastrophe for everyone. We'll never figure this out. I started telling my clients at that point, we have been through a zillion changes before, and the people in this business can figure out how to do it, and we're going to figure it out. It may not be perfect the way it is, but we can figure out how to work with it. There'll be changes, hopefully, to help that. The other thing that I like to bring up is I'll suffice this with a question for you to think about. Maybe is standard of care. How many of you know what a standard of care is?
That's one of my questions, Jack.
Oh, I'm sorry.
It's okay. We'll get to
Forget
that
you heard that.
Only 3 people raised their hands, Jack.
I echo Joel in a more global sense. Is the way that I see brokers getting themselves in trouble is when they try to provide other than real estate services. When they start saying, well, you send this notice at this time, or I'm going to follow the inspector around to make sure he doesn't miss anything, or that kind of thing when they're going outside, or they go down and do the land use planning for the client. And or I'm sure that they recently remodeled, I'm sure they have all the permits. So when you go outside, when you do other than real estate services, because that's all you have is service. You can't hear me? Yeah. A little closer. That's all you have is services, the same as us. That's all we do is service. We don't own the listings. You don't own any of that. Just stay within real estate services.
That's good advice, but it's a tough one. So that's another question. Where do you advise? When have they crossed the line? Because for them, their client, they are the first point of contact, and usually the primary, and not only, you might have your lender and others, but the primary point of contact for the clients, they do expect them to be everything. And it's tough because they are service oriented. And what would you advise them? What sort of I can't do that type of language, or would you advise them to tell their clients, because they're asked every day to basically practice law? They really are, right?
I'll give you one big one that's been the subject of several cases that we've had to defend. The broker, in their infinite wisdom and trying to be of help to their client, goes down to the city or the county to check on zoning or uses for a particular property, gets bad information, communicates it to their client, who makes a decision to buy, later to find out that the house that was on this property, it was actually, in one case, it was a modular home, had been placed there originally with a hardship permit. The property had been split. It was an illegal use of the property, and it had to come off. And that was a multi-hundred thousands of dollars problem. We see brokers doing those things because you want to help your clients. And you think that you need to be the all for them. And the answer is no. Stick within strictly what you do, listing and selling properties, and defer to other people outside, experts, if there are questions that are outside of your area of expertise.
Jack.
Jack.
Is it that time?
Remember, were you guys at Brian's class? That's the weapon, see? Keep an eye
Yeah.
to save yourself.
And I've seen him like that, and he's good. Well, one example that I have seen, which I think is a really difficult barrier to get over, is the telling your client when to get good advice. When you jump in and start doing something, you can create a major problem. But if you will stop and think that anything that requires expertise that is outside of your normal duties, keep your mouths shut. Write a note and do put it in writing to your client, advising them to see some particular kind of an expert, whether it's an attorney or a land use planner, an engineer, or whatever, and do that every time. An extreme case I had, the right advice was given to a client one day, almost an identical property. The next day, he didn't give the same advice, and a panel of arbitrators said what he said the day before, which in our minds would have applied to what they were doing the second day, what they were looking at. He didn't repeat that advice, so they said he didn't give her advice on the property, the second one that she ended up buying.
A lot of times what we say is, don't be the information source. Refer to the information source. And as Jack says, document that good advice. That's for your client's protection as well as yours.
if you read the real estate sales agreement done by OREF, there are at least 5 places in there where it says the buyers and sellers agents are not qualified to give you recommendations in this area. You should seek expert advice. If you breach that, as a matter of contract, you've gone outside things and you will be found responsible, especially if you get it wrong.
Should they read the sale agreement?
This is pretty scary.
But
Who reads the sale agreement?
Yeah, right.
People don't
Yeah.
read them.
Go to the sale agreement and you'll have a good bright line test of things not to do.
Yeah, one of the things I've seen over the years, and I'm sure at some point in your practice you've defended or assisted someone, is you're out showing a property. It may not be your standard subdivision property, whereas the boundaries, they're right there, see? And you just assume because the posts are there and you make the representation where the boundaries are, and guess what?
Yeah.
Have you seen those
I'm sure
cases
we've
in
all
your
had those
practice?
cases many
Yeah,
times.
right now. Right?
Yeah, exactly.
And I handled a number of those kind of cases with the real estate agency. And of course, I had to find a violation because you didn't provide enough information and you took it upon yourself to give them advice that you weren't really qualified to do.
Don't own it. Right?
Yeah, and also when your client says, the seller, yep, that microphone right there, that's the corner of the property. I wouldn't be communicating that to your client because then you're repeating something. And if that happens to be incorrect, and we've had that many, many times, you're going to be held accountable along with your client and doing a lot of E&O work.
Do you think
can
it's
tell you it's a big deal.
reasonable, under Joel's example there, for them to say to their client, if they're representing the buyer, the seller told me, or the seller told me the boundary lines are X, they should follow it up with, well, if that's important to you, the acreage or the boundaries, then you need to do your own due diligence and have a surveyor come out, or as long as they're not owning the statement personally and attributing it to the proper source.
And people have a very short memory. When you pointed it out and you said, oh, the seller said, then you better be documenting that because you're repeating it. And what they will remember, if there's a claim, is that you said it.
One of the older examples of that, which still comes back to bite us now and then, is when you tell somebody what the square footage in a house is. We've all been through this. You know that there are quite a few sources. And if you will pick one, whether it's county records or a survey or something else that is a reliable document, and refer to that, just as Jenny was suggesting, that's probably going to get you off the hook, but it's a big probably because I'm seeing too many decisions from arbitration panels who want to help the buyers and sellers and will put a heavier burden on you than even the real estate agency thinks that you ought to be carrying. So, just try to stay away from making those kinds of statements at all, and tell people if it's important to them, here's a resource you can go to.
One of the things I always like to find out the standard in the industry. What do you think? How many think your clients know where the boundaries to their property are? How many of you know where your boundaries to your property are? Okay. Less than 20%. So the idea that you would say to someone, the boundaries are here, or the seller says the boundaries are here, sounds like a representation about where they are, when in this room, nobody believes that their clients know where they are. The standard in the industry would be, if these are important decisions for you to make, you should find out where the boundaries are. Well, how do I do that? Well, the most sure way is a survey. Well, does anybody do a survey? How many people do surveys? So the rural communities especially. There are not enough of them done. And because so you need to communicate in a way to say, I'm not telling you where the boundaries were. I don't think the seller knows where they are. If you want to know what you're buying, you're going to have to find that out for yourself or require the seller to pay you, tell you where they are. And so then your buyer knows it. How many people own you talk documentation? I think this is the other issue that I see a lot of. How many people own a smartphone, right? Hey Siri, I just called John and told him don't buy this. I just called John and told him don't buy because he can't tell where the boundaries are.
That's why we call
There's
it
my note.
surly.
Yeah, that's my note. I drag that into the file when I get home, and I've documented that I had a conversation with John about where the boundaries are and aren't. It's that simple, and that's good documentation. I start encouraging you to do that.
Excuse me, Jenny. So one thing I want to follow up with is I teach a lot of classes just like Richard and Joel. One class, because this documentation issue is so important to all of us, one class I started off with a banner that said documentation, and I stood over there and stared at it for literally 10 minutes because I wanted that word to soak in. I don't know that it did, but I felt better that I really got the point across.
Yeah. Okay. Well, what do you think of, which, following up on this point, on their MLS printout sheets, it says deemed reliable but not guaranteed. What do you think of that little disclaimer? Is it going to save them?
Does a disclaimer save you?
I think it's a confusing thing.
Yeah, absolutely.
I've never seen it prevail.
Exactly.
Yeah. I think you tell someone if the square footage is important to you, you should go down to the county, or actually here's a tape measure. Start measuring.
And that statement, yes, buyer, you can rely on this, but no, not really.
Right.
I mean, so it's. I've always thought the same thing. I'm like, who is this here to protect? Because it's a false sense of security if you're going to court.
The as-is clause in the sale agreement is the same way, right? Yeah. You're buying this property as is, except. I've never seen that clause prevail in any case either.
Yeah. All right, so let's go to Jack's favorite issue, and that's defining the standard of care and what it means, 696-301, which is our favorite statute in your real estate licensing law, which is the disciplinary statute. Section 15. One of you want to give a brief of what Section 15 of 301 says, what that means, and then let's talk about that.
Well, I don't actually have the language memorized, but to paraphrase, it says that every real estate licensee must comply with the standard of care, or you can be found in violation of the statute and various disciplinary actions by the agency if the allegation is proven to be true that you did not comply with the standard of care. The problem, of course, is what the heck is the standard of care? It varies a lot and legally can vary a lot from one part of the state to another, because to some degree it's based on the practices of the realtors in the area that you're working in. But there are a lot of other factors that enter into that, including court decisions, decisions by the real estate agency, pronouncements by the real estate commissioner. Go back a few years in the 90s to the man-made siding issue that we got into with LP at that time. Finally, in order to settle what the standard was, the commissioner at that time wrote the lead article in the News Journal telling you what the standard of care was, and announced in that article that anyone who didn't get the message didn't get it because they aren't reading their news journal. And that in itself did not impress him a lot. So he made sure that people understood that they had to be aware of information that is going around, read the news journal so you know what the agency is saying. And we continue to see tidbits of articles like that with commissioners telling us how we can do a better job. There are just knowing what the practices are in your area is not easy, but you need to pay attention. And you need to pay attention to what's going on in the area that you're working in, because if you don't know your area, you're very likely to take some kind of a risk and endanger your client in a way that will cause a lot of damage to them. You know, there are a lot of examples around the state. One that was not an issue for probably close to 100 years suddenly became an issue. This is in Southeast Portland, where we had a sewer line put in about 50 years ago. A random person in that area actually connected because it wasn't required. The city started at some point, we couldn't even pin down the date, started sending sewer bills to everybody that lived in the area. And one by one, they seemed to start paying the sewer bills, even though the majority of these people are on septics. So, you know, we get pretty far along. There was not a broker, not a resident that I know of that knew that the majority of these properties were on septics. And so every sale that took place, it was represented that it was a sewer. And, you know, we're having brokers recommend that they have the septic tank pumped Apparently nobody did because they wouldn't, they would have discovered that, or I'm sorry, I said that the wrong way. They said, get your sewer line scoped, and people didn't do that often enough, at least. They didn't realize that they didn't have a sewer line there to scope, and they would have found out if they'd hired somebody to do that. The initial results of that were in a complaint to the agency, and this is probably about 10 years ago, was to say that there was no reasonable opportunity for the seller or the broker, the listing agent, to know about this, and there really wasn't. I was representing one of the parties involved in that, and I dug every which way I could find, and there was no reasonable way because they're all paying a sewer bill. They're all assuming that everything is fine. Somehow, nobody in that area that was hooked up to a septic had a problem, so they didn't call for help that would have told them about this. So, this is one of those things that initially nobody has a fair chance to know about. So nobody was found guilty of any kind of a violation of law. No fault in not knowing what the standard of care was, because in fact they met the standard of care that existed up to the time that was discovered, and a lot of publicity started getting around. That changed the standard of care. Then people in that area, brokers working in that area, needed to be paying attention to the newspaper and the televisions, just like they did with the LP sighting, and start to recognize there's an issue here, and I'd better start talking with my clients about this and make sure that we know, in fact, what is going on. See, there were just a few that were actually connected to the sewer, and the city argued with me at length that every property there was connected. And, we virtually had to drag an inspector out and ask him to show us where the connection was. But, these changes make this doubly difficult. But by golly, that's part of what you bought into in being a realtor, is that our lives keep changing all the time. The rules, the practices, the materials, everything that we deal with, and you just have to do everything you can to read and absorb what you're looking at. Another quick example, in Bend, they have a lot of irrigation canals all through the city. Some buyers think that irrigation canal is the most beautiful thing that they've ever had, with picnicking on the water in their backyard. The next guy comes along and says, I don't want that. I've got a 6-year-old granddaughter and she'll go out there and drown. That's a horrible problem. What do you do representing seller and buyer in a case like that? You don't know whether that's going to be a good thing or a bad thing to any prospective buyer. So, tell them what's there, make sure they think about it, send them to somebody with some expertise to help out. But my main point is you have to be doubly observant about what's going on in the area that you're working in, the kind of properties that you're selling. You have to know more things or certain things if you're dealing with a house on a lot. Quite a long list of other things if you're dealing with rural properties, properties on wells, properties that are purely agriculture, circle irrigation systems, and so forth. You take on one of those that you don't understand fully, you're nuts. You've got to affiliate with someone who does know how to handle those, and then you can learn the standard of care. You'll learn what you should know in dealing with that kind of property or properties in the area that you're working with. So maybe a little too long-winded, but that's
It's kind of like working outside of your area of expertise, which we've had those cases for ages.
It is difficult because there are so many neighborhoods with pockets, just like you said. It just got me thinking there's a neighborhood like Oswego where you think everyone's hooked up to sewer, but they're not. So how do you, and especially if the seller is getting a bill from the city, what more can they do? For them, they're off the hook. You ask the seller, are you connected? Yes. There's no red flags. There might have been a couple homes in the neighborhood that they know are connected to septic. Should they go one step further, or should they take the seller's word for it?
You would have probably recommended that they have a scope then, right, of the sewer. That probably would have got it.
I'm going to start reading it at section 15 that you mentioned. You can have your license suspended or revoked or sanctioned in some way if you engage in any conduct that's below the standard of care for the practice of professional real estate activity as established by the community of individuals engaged in the practice of professional real estate activity in Oregon. And that's at what Jack and
Right.
Joel are talking about, is that you have different communities, and you can be macro about it. I had the call from a lady in Albany, Oregon. They want me to get a sewer scope. I don't even know what that is. In Portland, North Portland, the sewer scope is a matter of standard practice. You must have one if we're going to do this transaction, because they have up there, the community knows there's party sewer lines. The city of Portland has sent out a notice saying all party sewer lines are verboten, stop it. So you have broad communities. If you're in Portland and you're out in Lake Oswego, and you go to North Portland and you're out of your area and you forget to mention sewer scope, you're going to pay, because the standard of practice in that community is to get a sewer scope to make sure there's no community line.
Yeah, exactly. You know, the other thing that catches people kind of working outside of their area, and the area can be literally from one side of Portland to the other. And the most flagrant case I had was Oswego with a Portland broker who showed an out-of-town client property in Oswego. The client ended up buying it. It turns out an adjacent piece of property, which was a public school, was about to be raised, and they were going to build up this property. The property in question that was sold sat up high. The school was down below. When the school was rebuilt, they were putting in lights that were like 20, 30 feet in the air to illuminate the parking, which now illuminated this house. And the poor broker that came out of Portland, who was a very good broker, didn't know that this stuff was going on. The listing broker, as it turns out, did. The seller knew and complained about it with the school district because it was going to ruin the value of his property, but nobody told the buyer. And so that's an extreme example, but a big time one that can catch you outside of your area.
And there's another example that I think takes this about a step further, and that is when we have the tram in the planning stage in Portland. We've got a lot of publicity on television and in newspapers. You people have got to see that and take that to heart, so that if you're over in that area at that stage, there's nothing physical on the ground to tip off a buyer or a seller about what that may do to the value of their property. But you have seen an article about it. You have to do some research to find out what's going on, but don't be the expert that gives your client the detail. You refer them to someone who is maybe a land use planner or a county planner, and have them go have the conversation themselves. Don't let them come back to you with the questions that you asked and the answers that were given by that planner. Because if they're wrong and you endorse that, the planner said it, so it must be right, you've dug yourself a hole that's way too much to get out of. And these problems just keep coming up. Things keep happening where we are having things discovered that we didn't know about.
Yeah, and that
You've got a
deductible's
microphone.
brutal.
Did you bring your own?
There's a couple questions we'll take.
Julie Gilbert from Hood River. Mine's kind of a two-part question. It comes to the standard of care. We're in a smaller rural market, and we're seeing more and more agents coming from outside of the area. We watch our sales closely, and so we know these agents are doing one deal in one deal. That's it in our area. Are we just not seeing a lot of lawsuits about standard of care? Because to me, they're coming out to an area where they don't regularly do transactions. So I'm surprised that their broker will let them do business out in that area. Are there just not a lot of suits about it? Because to me, if I was a principal broker, I would never let my broker do 60, 70 miles away one transaction in their career in that area.
Quick answer for me for that question is I testify as an expert in a lot of arbitrations and a few trials. I have not been in a case now for probably 7 or 8 years where standard of care was not the major factor that case turned on. Right. So it is happening, not maybe in your area or maybe not on that particular subject area, right. But standard of care is totally common, and and that this is a kind of an issue that I think is just there's a principal broker who maybe isn't doing a good enough job of supervision. but principal brokers are not charged with the duty of tracking their brokers to see where they're traveling around the state.
And you're not
But
going to
they-
hear about it because it's arbitration. I mean, we don't have enough litigation to educate you all on really what to do. Arbitrations are private. These three are probably involved in a lot of them. And this is your best resource right here. You're not going to read about it because they're not public.
Yeah, that standard of care kind of does tie in with the claims that we see when we're defending these cases. Because of a breach of the standard of care, somebody may make a negligent misrepresentation to their client. And that's kind of where it all kind of meshes together.
So sorry to hijack the microphone, but my second question on that is when these agents are coming out, they don't know home inspectors or anything. So they end up looking to me for the resource. I don't necessarily want a home inspector from Portland that I've never had out in our area. So I've tended to give them the name of 3 home inspectors in the area. I kind of want to start saying, I'm not going to give you anything, but I'm stuck in this position of, okay, if I don't give them the name of the 3 that I would give my buyer, then I'm going to end up with some person that's willing to travel 70 miles for a home inspection. Is that the person so I don't know what to do because they're looking to me to be the resource. I seem unhelpful, like not helpful if I say, listen, you're on your own. You're in an area where you don't know. I'm trying to put the deal together. What would you suggest? Am I getting outside of my area if I give them 3 names of home inspectors in the area? I mean, that's all we have
In other
anyway.
words,
Yeah.
when can she tell? When can Julie tell the other agent,
Yeah.
go pound sand, you're on your own without violating her fiduciary duty? to
And
her
you can
client?
certainly do that. Tell them to pound sand. However, the world is round.
Yeah.
It will come back. But yeah. So,
And there was a question.
giving several names out, I don't see that as problematic.
And I'm seeing that stuff too, because I have a lot of friends that live in that area. So I'm starting to see them, but they're not reported cases because they're all arbitration.
Yeah, that's true.
And they're not. So there's no appeals. There's no those kind of things about them. But it's not just out of town. How many people will sell condos? How many people think you can sell a condo? Right. That's a whole different thing.
It is.
It is, and probably half of my cases in litigation involve condos and condo docs, and Oh, I'm sorry. I usually speak loud enough, but condos are their own thing. About half of my caseload right now is all about special assessments that weren't disclosed, and you get your client. I had my most recent when they were putting their key in the door, and the neighbor said, "What do you think about the special assessment? How much is it? $185,000."
Yeah.
She pulled her.
Or it
pulled
shows up right after closing.
her- Right. Yeah. Right.
And then you go back and you look at the board meeting minutes and see that this discussion has been ongoing for the last, couple years, and that they voted to go ahead and assess.
So what are you selling in is really important. That's all.
One interesting data point for the room and these guys in our area, which is the North Oregon coast, 25% of the sales are from out of area realtors. But my question, and it's kind of for all 4 of you, is Jack, it is such a pleasure to see you again. I've been around for a long time, and gosh bless you that you're still here for us.
As long as you're sitting there.
I'm nearly gone.
Jeez, I'm gonna have to prop Jack up now. Jeez.
But when you were with the agency, one of your investigators, Sharon Woods, I don't know if you remember
I
her.
remember her.
How can I forget?
I remember her very well.
She told me that what we actually did as realtors was practice a specialized form of law, and that was the standard that the agency was holding us to.
I'm going to be a little blunt about the response on that. Sharon made a number of pronouncements to people that she was talking to, some being investigated, some not. Sharon investigated people who had no complaint, and when she found a problem or thought she found a problem, she would find somebody who would file a complaint. Sharon lied to me about the evidence she had gathered. She completely concocted a set of evidence to support her dislike for a buyer. I attempted to fire her at that point and was stopped by the state hiring system.
Very, very nice person.
And all of that is true. So, you know, if she hears that I said it, it's absolute truth. You know, unfortunately, we don't have every investigator there who is really skillful. I don't know anybody else who has misbehaved the way she did, but all of the people that are there today, I will agree with in most cases. In a lot of cases, I don't. That doesn't mean they're bad. They have a different perspective. You know, so I think for the most part, we can rely on them as doing a good job. Sharon just had a bee in her bonnet, and, you know, we couldn't, it took a long time for it to go away. Pardon me?
But when she told me that,
Yeah.
I realized, holy smokes, when she told me that, because I was the principal broker, I realized, you know, she's right. She may not be right in terms of a bunch of attorneys, and I stepped up my game.
Well, I think that's a great benefit if you did that, you know, and I think what I try to do in every class I teach is to try my best to scare you out of the business. So if you stay in, you know, you're going to work harder to protect yourself and your clients. You know, I wouldn't agree at all, because I think that's too easy to lead you down the path of thinking that you can practice law or get a little careless about crossing that line. I'm dealing with one of those cases right now, and you know, it's a pretty hazy area to get into. It's not something where we can just hand you a clear definition, but you know, it's an issue that I really would have concern that you might get a little reckless if you hear somebody from the agency saying that. Remember, I think the agency does a good job. That doesn't mean they're right all the time. And I know that Richard and Joel have the same experience. People call the agency and get an answer, and then call us and say, is that the right answer? And, you know, I tell them no sometimes. Then I call Selena over at the agency and say, you know, here's the answer that got out. If you agree with me, somebody needs to have a clarification about what they're saying in public.
Yeah, I think the reality is you guys do practice law every day. You've just been given an exception to have a pass the bar as long as you stay within your parameters. Look at your sale agreement. I mean, that's just my opinion. It's 11 page. Well, I don't know. I'm sorry. Or if it's whatever, how many hundreds of pages. And that's a legally binding document that you are asked to explain to your client. That is practicing law. You're just, as long as you do it within the scope of what your license permits, you don't have to be a lawyer. You don't have to pass the bar.
And what your knowledge is, you know, even if it might be within the scope of your license, if you don't know the right answer and you're sure that you do, don't gamble on it. Go get some input from your principal broker or from another broker in your office that has that kind of expertise. There are plenty of people around to talk to, and don't let your clients pressure you into moving faster and making a dumb mistake, because they don't see their pressure as justifying the mistake that you made when everything falls apart later on. You know,
And that happens in all professions. I have young attorneys filing circuit court cases involving the OREF sale agreement, when it's clearly you can't do that. And so you have to call them up and say, look, you've made a mistake, and I think you can bury that mistake right now. Do the dismissal, nobody. Otherwise, I'm going to file a motion and I'm going to win, and you're going to pay my attorney's fees for that. And those are discussions I know that you guys have had too with young attorneys. Yeah. So there's an ethical issue that I just want to, that we've been dancing around. The NAR ethics rules talk about, the preamble mentions, but there's the ethical rule on point, is that you need to help the younger agents and share your knowledge. And so the idea that if you have somebody coming out of your area, and I'm quick to point out to attorneys, look, I don't think you know what you're talking about, but here's why. Read this. And you might point out to people, like in Jack's case, I've had those cases too, out in Gresham. Part of it was they started billing every person who had a legal lot of record, because they ran a stub out off that sewer to every legal lot of record. And then they started billing them. 15 years later, when the grandkids sold the house, they had 15 years of sewer bill. Well, that means we're hooked to the sewer. And by that time, there's almost enough that the city will give back to you to hook it up. But coming back to the ethics issue, the ethics issue is you have some obligations to people who to help them. One of the ethics rules talks about you cannot, I said this yesterday too, you cannot take unfair advantage. You can take fair advantage, but you can't take unfair advantage. And the idea that someone comes in and you're seeing them obviously make a mistake that's going to be no sewer scope. Well, that's going to kill somebody later on. You should do a sewer scope. I highly recommend it. Everybody in the area does. If you hear that, the community standard has been set for you. You're not telling them what they're going to find or anything, but you're going to tell them the things they should do.
And I can tell you, if you take the time to prepare some documentation to do exactly what Richard is saying, and then you get a complaint against you, and you go to either of them or me with that complaint to try to protect you, our faces light up because you did such a good job. We can win this case, and I think it's just that important. It takes time. You have a smartphone, put it to use. Technology is a pain in the backside a lot of times, but there are some great uses for it, and that's one of them. When I see a client that's just loaded with that kind of documentation, I love it.
Well, I know both of you guys. We've called the agency and said, "Have you seen this stuff?" And they go, "Yeah, we're just missing." Yeah, they just go away. You see other attorneys, "Have you seen with this stuff?" And they just say, "Yeah, I think our case isn't worth what I thought it was." Documentation will save you every time.
Which kind of gets back to you're a member of MCAR, aren't you? Yeah. Going to be down there in a couple of weeks. We represent MCAR. It gets back to that broker that came from another area that doesn't really know the rules, and it's irritating as hell, I'm sure, because they're just swooping in, they're getting a deal, they don't know what they're doing because they're not familiar with the area. But by the same token, if it's an unfair advantage or even a fair advantage, the problem is that something's going to happen after if they goof up, and that will have repercussions all the way down the food chain, meaning that typically you'll see the listing broker and brokerage, the selling broker and brokerage, and the buyer and seller all involved in the same dispute. And so there's a high probability that even through their goof up, you may end up being implicated. Yeah.
Okay, a couple questions back there.
Was it my turn? Thank you. Going back to condos again, when you're selling or listing a condo, you have to provide all the documentation from the HOA, and it's often 200-300 pages. What happens if let's say you're representing a buyer and they refuse to read through the documents, and you say, "I know you're busy, Bob, but you need to read the documents. We only have 5 pages."
You document that good advice. That needs to be, either as Richard is suggesting, or even an email. I like emails. You put a copy in your file that you advise them, and it's very essential that they read these, or they go to someone that will read them for them, such as lawyers or someone else.
Are you expected as an agent to read it yourself? I mean,
no, but there are certain basic things, and we've probably all had this case. Somebody wants to maybe use this residential condo for a commercial purpose, and the listing broker is aware of that. Maybe they have both sides of the transaction, and they should at least have sufficient familiarity with some of the very basic things that deal with it. But I think it is a trap to, you can go read the 300 pages, that's fine, but it is a trap for you to be commenting on those and what they really mean, their interpretation and how it will affect somebody. But knowing some of the basics, especially, either side of the transaction, I think is quite critical.
Go ahead, Jack.
Okay. I just was going to give you an example. Those of you who have been in my classes, I don't really teach per se. I give you cases. And a case that I got involved in probably about 3 or 4 years ago, we had a seller who got the offer. He and his wife made a handwritten in change on page 8. They both dated and initialed and handed it back to their listing agent without telling him that they had done that. But that was compounded because the listing agent didn't look through it and didn't see that change was there. He presented that to the seller. There was something else in there too that he had made a change that was obvious, so it was going to be a counter. He gave it to the selling broker, who did not read through it. The buyer did not read through it. A complaint went to the real estate agency, and I won't go into the detail of all why that happened, but a complaint went to the real estate agency, and by golly, wouldn't you know it, the real estate agency didn't read through it either. what that amounted to is that we had an agreement that had a change that no buyer had agreed to. The agency tried to argue with me and convince me that when the buyer accepted at the bottom, that was an acceptance of that penciled change in the middle. And, I finally persuaded them that was not going to be the case, and reminded them of the commissioner's, at that time, words of advice to brokers that you don't need to hire an attorney to represent you with the agency because you're going to get exactly the same deal all by yourself without spending that money. This is a case where if I hadn't gone through that and found that, my client was going to have a problem. But I showed that there was no agreement there in the first place, and therefore the standard that they were trying to hold her to in carrying out her duties with an accepted agreement was void. It wasn't accepted because of that change. The problem was the carelessness and nobody reading through the document or even flipping the pages a little bit so they could see if there was any change like that made. It doesn't happen often, but it happens occasionally, and it happens to all of us. We all make those kind of mistakes. It's just more fun to catch somebody else than being caught doing it yourself.
So Jack's, I'm sorry, Richard, go ahead.
Well, so the idea of what you're doing with your buy and sell docs, those are absolutely critical because you're responsible for those. But when you go to the HOA docs, that's a whole different standard. Those are documents that, and I will tell you, this is my strong recommendation, is that you keep an inventory of the documents you gave to them, and you have something to document said, these are important documents, you should read these. And I would encourage it, you put, I haven't and I won't, because that's one of the places where it's not your expertise. In Portland, we have 3 or 4 services that will do that for your clients. You can make that referral. They need to look at reserve studies on those kind of things. But I would strongly recommend do not read through those, do not hint that you will, because if you said, and I've heard this, had this case, I looked at them, I didn't see any problems, but I want you to make sure you read them carefully. And what did they hear? Oh, there's no problems with these. That's what we say and what we hear is 2 different things. Right.
But do you think that a court, so on the HOA docs, and let's say you have brokers out here who regularly sell condos, doesn't that raise the standard of care for them in that situation when it comes to red flags in an HOA doc? Or do you think everyone should at least have a basic understanding so you can spot the red flags and then point them to the resource to assist if there's a question? I mean, how would they know what's a red flag? You look through 200-page HOA, there must be some standard red flag language. How would they learn that?
That's kind of part of why you maybe shouldn't be selling condos if you don't know those things.
But
It's
where
like
would
working outside of your area of expertise.
Okay.
My view on that is that's going into the wholesale practice of something that's not within your expertise, because the services, they're not lawyers, but they are very experienced, and for between $750 and $1,500, they will read through those and tell you the things that are particular to that. And it's very common that they've read those before. And they said, and so they know, and that's how they cheapen their bill, but they know what's wrong. And they've looked and they've seen minutes that would indicate there's something coming. Or they've looked at a reserve study where the reserve studies aren't enough. And so that's not things that real estate agents, I think, should become the standard of care. That's not the standard of practice now.
I agree.
Even within the condo sales people, that's not the standard of practice.
And there are a number of attorneys, us included. I've got 300 pages sitting on top of my office desk to review on a condo transaction. Lawyers review these things as well. And the cost is probably no different than these services.
So with that example, again, do you think it's adequate that they represent a buyer and they get the HOA docs that are a couple hundred pages? Sorry, I'm not sure what's in here. If you want to know if there's anything worrisome, hire a service. And I'm just asking if you think that's enough to get them off the hook if they document, say, I'm sorry, don't know, but if you want to know, maybe a special assessment's coming down, or
I might message it a little differently. These documents are very critical to your purchase. You need to very carefully review these, or alternatively, we'd strongly urge you to hire, an expert, a lawyer, a service, whatever, to review those on your behalf, as they may, affect your purchase, your decision.
sounds like an easy way to get off the hook on everything.
Well, but But
Well, it's
it's
not
an
being the
easy way to
information
say it's not
source.
my service.
Yeah.
That's not what I do.
I'm not the information source.
Yeah. And I think that's what should happen.
How many of you remember back to the time, probably in the early 90s, I think is about when it kind of came to an end, where the brokers were always doing the inspections for their clients, for their buyers? That was a really smart service, and that's why it ended. But that's just a very important point. Those kind of changes occur, and when we start seeing lawsuits that get you into a lot of trouble, let's have a look at stopping the practice.
Anecdotally, I had to defend a broker who went underneath the house with the inspector. This is over in Washington. And then the inspector missed something, and then the broker, they didn't know. They were just along because it was kind of interesting. And they ended up getting sued along with the inspector. The inspector had no E&O coverage and also did not have any assets. And he thought this was kind of interesting. So we went through a several-day trial defending our client, the broker, and the inspector represented himself and had a great time cross-examining and playing lawyer. And so you don't want to be doing those things.
Let me give you an example on the good side of this where I saw it handled really well. This was kind of an interesting case quite a few years back where we had a builder from California that moved up to Central Oregon and had a lot of experience. He was retired, bought a house there, but did not have an inspection done. The broker pointed out that it would be wise of him to do that, and he chose not to. The broker documented that she had advised him to have an inspection done, and that his response was, look, I was a builder for 50 years in California. I know more than any of these inspectors do. Turned out he was a little bit up in years and didn't feel like crawling under the house when it came time. And we had a major problem with heat ducts having been knocked apart. We don't know how that happened, but then he blamed the broker for not getting an inspection done or forcing him to, holding a gun to his head, and sued, filed a complaint with the agency. He lost all of those. But, the one thing that I say a lot is, you don't have to hold a gun to your client's head to make them do something that's right for them, but you do have to give them good advice, and we want you to be able to prove that you did so that we can protect you when the time comes.
If I go to
Everything
that,
leads back to the banner.
Yeah.
you're right.
Yeah.
If we go back to the theory that you're practicing law, we all document our files
Exactly.
with that kind of stuff. Told you to do this, told you not to do that. I've said, look, if you had $1 million, you should do this, but you don't, so don't. They do it anyway, and it didn't work out. I had one of those HOA things, single family residential with HOA. The broker said, yeah, it says no businesses here, and I know that you have to do the child care in your home to be able to afford this house, but look, there's 3 other child care facilities in that HOA. Must be okay. They 2 weeks later got the note. Somebody complained. I wonder who. That they were doing child care. The president. I wound up talking to the president. He goes, "Yeah, it's complaint driven." And so these other people do it because there's no complaints. And he said yes. And I said, "We'll fix that." The solution was that passed unanimously that they could have up to 4 child care homes in the HOA. That was the solution.
Doretta, or someone back there? Oh, John.
Janny, I got the microphone back.
Uh-oh.
So when you were talking about, young attorneys may try and sue on the sale agreement, which isn't acceptable because there's small claims mediation arbitration. REO companies and relocation companies will return the sale agreement with all those paragraphs just X'd out. And in the past, I've said to the people, I don't know what that means. Talk to an attorney or buy it or don't. You decide. Is there a better answer for that, or should they really seek legal advice as to what their options have just not become?
They don't know.
Okay, never mind.
Duh.
Never mind.
Next question. No.
Yeah. I think that's one Jack knows.
Yeah, Jack, you look so smart today. Yeah.
Well, to just maybe throw out a couple of possibilities, in cases like that, you may know that your client is not going to follow your advice to hire an attorney, but still recommend to them that they do that and have it in writing. Make sure they understand the importance of getting clarification, and that it is something that's beyond their expertise. You know, take the cautious route, I think, is always advise your client in writing to seek expertise from some appropriate source. And, you know, and of course, we've got the documentation then to show that you did that, and the statutes are in your favor that that is not one of your duties.
The email would say something like, the seller has crossed out very important provisions, or those that may be very important to you. And I would strongly urge you to have this reviewed prior to accepting with your own legal counsel or other advisor.
Maybe even, and these are inconsistent with the standard of practices in our industry using the statute. And I don't know what this might mean for you. You probably should get better legal advice on this. I'm dealing with the REO companies. The ones that I've dealt with, they don't even want a deal in writing until the day of closing. And by the way, we're going to keep your earnest money if you try to back out.
Yeah.
And so those are the kind of issues that your client should know about. Like, if you send their earnest money, you're never going to see it again. It's in Chicago in the first place.
Yeah, it goes out of state.
Yeah, and you're never going to see it again, and you won't know whether you're going to close until the day of, and they come to closing because there's not going to be a deal. I've had to give that advice. A realtor should not be giving that kind of advice.
Any other questions before we?
I just have one.
Julie.
Sorry.
Doretta had one too, didn't you?
So I've had a couple of clients ask me lately when we get the seller's disclosures and the home inspection back, they're looking to me to tell them what to ask for. I know what I like to ask for as repairs. Like, let's take, the home inspection comes back. Well, what would you ask for? I know part of that could be answered in terms of negotiation, but I think it puts us sort of in a hot seat of telling them which things to ask for and which not. What do you say would be a good response to a buyer that wants you to define what's important?
Well, when they're asking you what would you do, that is a trap. That is really a bad, that means I want to push the responsibility over to you in case what you want to do isn't the right solution. And we as lawyers get that all the time. I mean, and that's not a question that's appropriate to answer other than to say something like, this really is your transaction. I'm not you. We need to go through this. You need to determine what you feel is important to you. And if you need some assistance, then maybe you should be talking with some expert, maybe a construction contractor, a home inspector, or someone to ascertain what should be asked for.
I agree. I've had to answer that question, and I come up with the presentation of, look, that's all in the eye of the beholder. When we bought our house, it had a 20-gallon hot water tank for a 3,500 square foot house, and I'm ready to buy this house, and my wife said, no, we can't possibly buy that house because the hot water tank's not big enough. And so that was an easy solution, but that's the kind of thing of, well, what would you do? And my wife would have said, not buy the house. And
showering once a week is not a good solution.
And I'm just saying, look, I'll have a bigger one delivered, right? So that's just, what would you do? It's all in the eyes of the beholder. And
so what do you guys?
you.
How would you advise Julie in that scenario, or any of them, if they said, when the client says, "What would you do?" Would you ever advise them to tell their clients, "Well, let's check with your lender to see if there's something in there," because appraisers or maybe lender required repairs, right? Okay, I'm just asking. I'm not recommending necessarily.
God forbid, don't do that.
Let's hear what the experts have to say.
Well, I'm going to stand on my ground of you send them to get expert help in writing. You cannot find two people who want exactly the same thing and then to add your opinion to what you would like. And you've got 10 kids and in-laws living with you, and they've got just a couple or something. The needs are so totally different that I just don't think that it's at all helpful or reliable, and is extremely dangerous for you to give your opinion. And you put that in writing, and I'm going to take this a step further, because I think this is an action on your part that ought to be done more often. If you have any kind of an issue with your client where they're demanding something that you should not be doing, and we're not going to get together fire your client. Ask these guys if they've ever fired a client, and particularly, did they ever fire one that they regretted? It's something that we, I'm not saying go out wholesale and start firing clients. You work on these deals, you put a lot of time into it. Do you want to keep putting time into it when you've got somebody who is so difficult that no matter what the outcome is, you're going to get a complaint? Let's bring this to a halt and at least minimize the issues that they'll be complaining about by not sticking with them. Talk to your principal brokers, figure out how that can be done, and if that's the right way. A lot of times we'll want to have the deal reassigned to a different broker who may have a different skill set that can work with it. There are ways to maybe keep that deal in-house and not throw it away. But, I personally have never regretted when I fired somebody or refused to take a client. What I found is...
He refers them to me.
And he's clever enough, he never takes it.
And I rejected Jack.
Yeah, right.
The success of your business is not who you do business with, it's who you don't do business with.
Yeah, I agree with that. So how many people, and keep your hands in the air, how many people have walked away from a client? Everybody who hasn't, look around how many people in this room have. That's wisdom. Yeah. Wisdom comes from mistakes, right? That's all that wisdom. So everybody here has seen the repair addendum, the OREF repair addendum, right? It has a whole bunch of I've heard the question, well, which one of these should I have do? And what should your answer be? What we've been telling you it should be that you should do the ones that you think are necessary for you to feel comfortable buying this house. Well, which ones would you do? I would do the ones that would make me feel comfortable, but you and I are not the same.
Well, Richard, why are we paying you 4% commission if you can't give us guidance on the sale?
Because I'm not ever going to live there. If you want my recommendation, do them all, because then you'll know. And then that puts them in do them all. I don't want to do them all. Well, then do the ones.
And if you checked all the boxes,
yeah,
they still don't have to do them all, right?
Right, exactly.
So
right.
That's pretty safe.
Except on lead-based paint.
Yeah,
right.
That's true.
They had an EPA. How many of you attended the session this morning?
Yeah.
They're super scared. I'm sure this is just going to add to it, but they left. There is an EPA auditor. You may have heard, we're the only state, because I've checked with my colleagues, they've started auditing some brokers' files to make sure the boxes are checked right, and if they're not, are they taking the right steps to document the files? And if they haven't, they can be fined, which nobody's ever paid attention to the lead-based paint provision. I'm sorry, you haven't. Even pre-78 homes, you might check the box because you have to, but then what? How many times do you see your buyers do lead-based paint inspections?
I have a client right now who's in the midst of that, and they have been threatened by an investigator from EPA with a fine in the $180,000 range. We hope to do a little better than that, but this is the kind of figure that we're talking about.
Yeah, they're looking for money, state agencies, federal agencies. Okay, Doretta, you've been waiting.
Different subject. I'm Doretta Smith. I'm owner, principal broker out in Newport. We too are having a lot of out-of-area sales, which is okay. One of the things that concerns me from a legal liability standpoint, and like your input on, is we're seeing brokers being paid $50 to open the door because the out-of-area broker doesn't want to come to our area or can't come to our area or whatever. And I'm just wondering what legal liability that creates for that broker who opens the door, because we know the buyer's going to have a gazillion questions.
Pick me.
I think I handed out a couple dozen sanctions for circumstances like that. The agency, responds to complaints. They don't go out looking for these kinds of issues. So if somebody doesn't report that kind of bad performance, there's a problem. First off, the standard of conduct that the agency has well established at least 25 years ago and has stuck with is any broker who writes a listing or any broker who writes an offer without personally viewing the property is going to get a sanction of some kind, and depending on what kind of impact, it could be anywhere from a reprimand to a suspension probably. So, where I'm going to start is, if you have people that are not looking, that are writing listings and offers, and we have a lot of that at the coast because the people own property there but live in Portland, they go find their broker up there, and they don't want somebody from the coast that they don't know. It's that Portland broker who agrees to do that, who is sticking his neck out, And if you folks find out that somebody is doing that kind of thing, they offer you the $50 to go open a door and they've never seen the property. I don't like the idea of turning people in. Big part of my business is defending brokers, but when somebody keeps making mistakes like that, I think they need to get an education. And the best way to do that, if they won't respond to you and your principal broker talking to them, is give the agency a heads up, and they may want to handle it in some different way. But it's important to get people educated, because you cannot. It goes back to some comments Joel was making earlier about knowing where boundaries are. One of the cases that I got involved with was the broker in Portland relied on their client, who drove down and thought they had figured out where the lines were because they had talked to the listing broker down there, and everything was wrong. So the guy that I nailed was the selling broker, who didn't get off his rear end and wrote the offer and thought he was going to get a commission for doing nothing.
So you think liability would attach simply
my
for
concern
But your concern is
opening the door?
Yeah,
you're
the
getting
legal
the $50
liabilities on the
and
other is
opening the
that-
door.
Yeah, the E&O insurance is a $2,500 deductible. They got $50 for opening the door. And obviously the buyer's going to answer a bunch of questions, and they're a local broker. When I called our E&O insurance, they said, oh, we'll defend you. So just wondering what you, as attorneys, view as a legal liability for the broker who's opening the door.
What about the
quote
broker who
unquote.
opens the door but
Yeah.
doesn't answer any
So.
questions? Hey, here's the house. If you're
Yeah.
interested, you're gonna have to go back to your agent and deal, or more information offer. But
Yeah.
just opening the door, you think that's enough to cause some drama at the agency?
It's
Yeah,
possible.
And you may win in the end on some of these cases that we're talking about. But
At
have
what
you
cost?
have you thought about, and forget the attorney fees. Well, I have a lot of clients who seem to do that, but that don't mean literally.
Those are the ones we refer to you.
What you need to think about is that if you get a complaint to the agency, you have a chance to respond, and you may convince them not to investigate. But if they do decide to investigate, you can count on spending the next 6 months to a year responding to things like requests for documents, doing interviews, laying awake at night, not sleeping because you're worried about what the outcome is going to be, worrying about, oh gosh, it's deposition time. I'm just going to get ripped apart. People have their careers damaged far more by all of this time and worry that it takes than by the attorney fees. We don't want you there in the first place. That's what our practice really is all about. Fundamentally, is teaching our clients how to do things correctly, so that you don't end up with a complaint. And if you do get a complaint, the place that I go to first is I look at that complaint, and I'm pretty darn good at knowing what the agency wants to hear, and making sure that the stuff that they do here is what I think is going to keep you from having them make a decision to investigate. I want you not dealing with a complaint or an investigation. I want you to be able to get your mind back on your work and not lose sleep for 6 months.
Well, I have a question on that particular thing. Being proactive in your RMLS remarks. Hey, you've listed it, and in the RMLS remarks, Portland brokers. If you want to send your person over for $50, I'll show them around. Nothing wrong with that.
No.
Get the $50 and direct contact.
And then ace them out of the deal.
Well, no, that would not be fair.
I'm kidding.
That wasn't us. We were in the
Not
lower
that
chair.
mother.
She's on the high road up there, right?
I think I would decline the $50.
Yeah.
It's not worth it.
That's kind of where I'm coming from.
House for 100.
Make it worth it.
Sonia Lovis, Martech Real Estate on the Oregon Coast, Newport. What about the broker who writes an offer for their client and never discloses that the client has never seen the property, stepped foot on the property, the house goes under contract, and it isn't until you're into the 15th day of the home inspection they come and see it and say, nope, we don't like it, and then they back out for that. That kind of damages the seller. what can the listing broker do? I know what I'm starting to do is I'm checking on my lockbox entries, and if that broker hasn't opened that lockbox, I ask a direct question because I don't want the house to go pending and then back on the market because they wanted to hold it off the market for their buyer to have a chance to come
Yeah,
over.
did
and
they
see it.
have a
What
home?
is your, yeah, go ahead.
No, I was just saying, did they have a home inspection or not?
Well, they say that they do, but they schedule an appointment, they go see the house, and they cancel and they withdraw.
That's different. That's
a little different.
yeah.
A lot.
So can
I
you stop
can't
somebody
tell
from
you.
making an offer on a property they have not seen?
Yeah.
That's their prerogative. They could be out-of-state buyers. They could be on the internet. You know, they've looked this thing over 10 different times, looked at all the pictures. I don't know that they have an obligation, but from a listing broker standpoint, there's nothing that stops you from asking the question. But whose call is this in the final analysis? It's not yours. It's your client's. Seller, you know, we've got this offer from Joe Blow and Timbuktu. They haven't seen the house. What would you like me to do? Here is the offer.
Then you can tighten up the time frames if that's the
Yeah.
case. Just give them 3 days to get their home inspection
free service money.
yeah.
Do something that's going to get their attention.
The forfeit, well, if you don't get the inspection, you don't have a right to cancel the transaction. If
Exactly.
there's earnest money
Yeah.
out.
Yeah.
So now you forfeit the earnest money because you don't have a reason. So that means if they're going to do this, they're going to have to get an inspection so they have something to back out with.
Right.
Say it again. 5 days. Yeah.
Gonna get at least one or one
I have my dad, I think he was talking about me when he said, I can't idiot proof the world. These things are the nuances of things that come along, we're going to see those. And it's just when people get harmed, when a buyer, but recognizing, I think Jack's right, whose decision it is to deal with that situation. And it's always your clients, and because they're the ones who are going to be directly and most soon harmed.
question right here, and then Jim. And then
Hello, my name is Brett. I'm down on the southern Oregon coast in Brookings, and our office has had this discussion a couple different times. Our sales agreement changed a year and a half ago, I think it was, where now buyers don't give inspection reports to sellers unless the sellers request
that
it.
clause. We've been discussing this.
Which I don't object to, but my question is, there have been scenarios where a buyer's agent has spoken to the listing agent about issues in a report that the seller doesn't want a copy of that report. That conversation between the buyer's agent and the listing agent, does that become material and something that the listing agent may be required to disclose even though the seller doesn't have the report?
Okay, you've heard me all week. Yes.
Yes.
But let's ask these
Yes,
guys.
yes.
The agency disclosure pamphlet makes it really clear that that an agent knows about the house is not confidential information and must be disclosed. That's the short answer.
And you're an agent, and it's imputed to your principal,
Yeah.
the owner.
And I'm not sure as I agree with that as clearly as that line seems to be drawn, but I think I could, my agent never told me because I fired him the day before that or day after that or something. I mean, I think it's not that
Yeah.
clear, but
Generally,
if you get closed, then it might be imputed to you. But the agent has an obligation to disclose.
The concern that comes up when we're talking about this, and some of it's hypothetical, some of it's based on real scenarios, but a buyer's agent has an agenda to get them something for their client. And so I'm not so certain that the listing agent knows about a material fact just because that other agent told them.
So the issue is this: if you get an inspection report, the buyer gets an inspection report. Do you agree with everything in the report? No, we've seen that inspector. It was a different house or something, right? But you now have an inspection report, so you know someone is saying that about your house. And that has to be disclosed.
Ding, 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 ding.
Is that?
We've had a long discussion this week in a variety of committees
yeah.
about the sentence. Let's call it the sentence in the sale agreement about do not provide the home inspection report unless specifically requested by the seller. And then is that a subsequent breach? There was the legal hotline attorney in Washington has said not only is it a breach, but it's also problematic if, which is why I can't remember which one of you asked. Oh, Julie, about asking what repairs they should ask for. They said not only should you ask for repairs, you in that time frame you go get contractors to look at the report. You submit your repair addendum with specific bids from contractors. Like you get all that done in 6 days, right?
Yeah.
I have a different view of that. That contract provision says thou shalt not send unless you're asked for, right?
Right.
So to have a breach of a contract, you have to have damages.
Ding, 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 ding.
If someone sends you the entire report, and now you know that someone's saying that about your house, even if it's all a lie, but maybe some of it's true, how have you been damaged? You're never going to convince an arbitrator in this state that because you now know more about your house and what's wrong with it, that somehow you've been damaged. Well, I have to disclose it. And I have to negotiate my price down.
So what do you guys think about the clause in the sale agreement?
That should be removed. Should be removed.
Yeah.
Sorry.
There's no penalty
Sorry.
for breach of it.
Right.
The buyer's broker, without request, sends it to the seller's broker, listing broker.
Sorry to bring this up, but we only have 10 minutes left.
No penalty.
I have a question.
Essentially.
Oh, sorry, Jim.
Okay, that's right.
We forgot about you.
I've seen in my 41 years working out of Cave Junction, Oregon, which I know, no, I did not sell Sasquatch's cave. But anyway, I want you to know that we've had California brokers for years coming into our area and practicing real estate without a license. I've got a friend that sells out of southeastern Oregon, Ontario. They're coming over from Idaho. The teeth that we have in penalty for those people coming in and selling multi-million-dollar properties in our state is nothing. And they will pay that with a big smile on their face and leave the state. But if we go to Idaho, for example, and we did the same thing, I mean, it's like a $10,000 minimum fine. California's got bigger teeth on it. Is it bigger? Oh. Well, but that's the thing. These are people that are coming in a lot of times and listing property even in my marketplace. And then the other part, we live near Pelican Bay Prison. And so a lot of those correction officers and stuff are going into the Brookings market and our market because we are a zero tax state. And so they just love living up where we live and buying our groceries and all that stuff. But I just wanted to ask you guys, how do we get better teeth in the penalty phase of those people coming in and practicing in our market, and we are licensed in the state of Oregon, and we're being taken advantage of, I believe, over and over again. You can talk to agents out of LeGrand, Joseph, Ontario, Baker, Cave Junction, Ashland. I mean, it's happening all over. Brookings, Newport. Thank you. So what do you say, Jack? And Jack, again, you and I, we go way back. I actually, you came in and did a full forensic audit in my company one time in Cave Junction, but I really would like to hear what you guys have to say about that.
Well, I'm going to disagree with you about the potential. The potential is every penny of profit, their commissions that someone takes out of a transaction who did so without a license. The issue is for the real estate agency to know about these. They're far enough away from Cave Junction that they don't hear on the grapevine about these kind of things. A lot of times they have talked to people like you and know that it's going on, but they don't send anyone down to look for those kind of things. So, again, I'm going to come back to 30 years ago, 3 times. I'll tell you this: when I was with the agency, a fellow came up from the Central Valley in California, had a license down there, not licensed in Oregon. Did everything in violation of Oregon law and argued with me for a long time until he finally hired an attorney who told him what really could happen. we took $2 million away from him. And we, that was not something that had to be a single event. Let me tell you, there are different ways to skin this cat. One of them is to file a complaint with the agency, and I definitely think that should be done. But the DAs in this state have the authority to prosecute these cases. And if you've got a DA there in your county, maybe they feel a little more strongly.
Winner.
What are you waiting on? Take it to the DA. They won't always take these kinds of cases because some of them think that the real estate agency ought to do their job and handle it. But DAs are much better equipped than the real estate agency staff is to handle that kind of a case. When I was with the agency, some of them told me, no, we won't do it. But on occasion, I knew that I couldn't do what they could do, and I would talk with local DAs, and that's how we got the $2 million back. We went that direction, and the real estate agency was perfectly happy.
Did he have enough to lean to actually get paid, or was it just something that's still in virtual reality?
Well, in this case, we had liens that because he'd been up here messing around in Oregon quite a little bit, and so we had there were ways for the parties to get there.
It would be a very slow jurisdiction for criminal cases that would be willing to take that.
Jenny, you're an
Yeah,
ex-DA, so
from
am I.
Multnomah County, we
We
were
both were.
very, very busy. I'm not sure. I mean, their white collar crimes are that there are the units are much bigger.
Yeah,
given
I could
what's
never
now, but-
get a DA in a larger county to do that
not gonna
because they're just too busy. But this was it may have been, I can't remember for sure, it may have been Josephine or someplace, and it was a few years back.
Nothing to do
It is a
down there.
possibility, and I would always check into that to see if you can, if you've got a client who, is a DA, I'd certainly be talking to him about doing that and try to make sure he understands the importance of the local community and people that make their living there to do something about it. And he can.
So we have less than 10 minutes. What is the most pressing thing you all want to know from these three? 2 issues. And I have lots of other questions, but I want to know, this is your opportunity.
What's our hourly rate? That's what the question is.
I'm $1 cheaper.
Asking
than
for
that.
a friend. Oh. The new regulation? Because there's a new regulation that came out, right? Or something with inspection. Now the liability somehow is being transferred to you all. I know on the coast, I think that's the first place I heard of it out in Lincoln County, but hire a professional.
Education,
Are you? It's new.
All houses prior to 2004 needed to have a certificate of compliance.
I think it's when they're not just remodeling, but it's not as simple.
Go to the legislative actions and check it out, but be careful on your asbestos.
It's when you're taking stuff out. It's not, I don't think it's just a resale without remodel. I think there's some additional component
Trigger for that.
to this that, yeah, no, it is something to be aware of, right? In your market, if you have a lot of homes at a certain time frame and. Yeah, well, we need some case law, so get busy. All right, couple more questions real quick.
You started with a reference to Senate Bill 608, and I'm just wondering, has anybody heard of anything more coming to be added to that, or anything going to be maybe erased from that? It's very cumbersome, difficult to work with, and all the jurisdictions don't agree, City of Portland.
You should be sitting next door. Our lobbyists are over there. This week, our chief lobbyist said the legislators, we were hoping to bring one fix in the next session, which is to reduce the 90-day notice required on tenant-occupied properties on sales. Our lobbyists have said, the legislators have said, let's slow our roll on that. They're hesitant, of course, because if we go back in, then that CPI, they're worried about, like just happened in California, that 7%. They're just going to keep chipping away. So they want to, I don't know if it means another year, wait till the long session, but we will eventually get in there and propose some fixes, but it's sort of, the wound is still open.
And
So I'm not sure it's,
not anything coming up to relieve the no cause removal or paper.
you guys can speak on that
I
part.
couldn't
Can you
hear.
repeat the question? It was a little quiet.
Nothing that's coming down to change the no cause
Not from
disallowance
us.
type of thing. Okay.
Not in the next session anyway. Short session.
Look into that, maybe doing e-news or
We
something.
did. And Lindy, let's resend that again. We did when it was first brought to our attention
I
from
missed it, I'm
someone
sorry.
on Lincoln County. Well, I sent it. We drafted something in our news. That was several months ago, a couple months, 2 to 3 months. So there is. We'll resend it out maybe as a standalone. It was an asbestos. I don't remember if it was an article or an FAQ, but we did do something right when it was brought to our attention. We move slowly. I know, I'm positive we did something. I just can't remember exactly. Well, whoever, one of the state agents, one of the agencies. We did do something. We'll send it again. So, okay, one more question. Our last closing comments from our 3 experts.
I think as I listen to everything in terms of the seller's property disclosure statement, the inspections and all those kind of things, it's what's our role? What's our broker's role in that? And the broker's role is those are your client's problems that they need to be dealing with. You need, as the professionals that you are, is to set your client's expectations as sellers that you're going to disclose everything because you want a willing buyer. And as buyers, we're going to try to find out everything because we want. Once you know everything and you still buy, then you bought that. And that's you setting those expectations is going to help your clients understand the gravity of their role in the situation. They have responsibilities to find out what the HOA documents to say. The sellers have the obligation to tell what's wrong with the house or say, I don't know what's wrong with the house. I sell my house. If I won't, my daughter will, and she's like her mom. After 45 minutes in the shower, it would run out of hot water. That's the only thing I know wrong.
That's pretty good.
When you guys took your exam and passed, was the first thing you thought about, wow, now I can get out there and start filling out forms?
Oh, joy.
That's what your job is. I mean, there are a lot of components besides that, of course, but taking care of the detail is what your job is all about. It's what can make you or break you, and break you very seriously. Pay attention to the detail at all levels, not just when you're writing something, but when you are walking through a house. Don't get so distracted with your own conversation that you don't see what's in front of you and point the things out to your buyer. If you're representing a seller, one of the biggest issues that I hear about is getting a seller to be comfortable with the price that you're advising. Do your homework and make sure that you do a good job in giving them that kind of information to support your recommendations. Try to get them comfortable. If they aren't comfortable, you're going to have a problem at some stage with them. Same thing with the buyers. One of the biggest problems I see is that brokers run into difficult clients, and or brokers run into people that they're just not too sure of what they want, maybe can't afford anything, but they want something. You've got to get a clear understanding in your mind of what they want, what they can afford, and be sure that you're giving them a good input or sending them to people that can help them, so that they're realistic about their expectations. And if you don't do that, if you don't have that marriage of minds on what you're helping your client do, we're going to end up with a complaint to the agency or a lawsuit.
And to kind of perhaps summarize that in another way, kind of 2 points. One is don't work outside of your area of expertise. Number 2, don't be the information source, refer to the information source. You follow those 2 rules, you stay out of a lot of trouble, a lot of problems.
but they're still available to help if you need them. All right. Thank you, gentlemen. As always, it was a great hour and a half. Thank you very much.